University students in Australia have long been able to finance university fees through an indexed government loan, now called the Higher Education Loan Program, or HELP. In 2007, that program was extended to vocational education. Vocational education providers are much less heavily regulated than universities. Dodgy education providers sprang up, knowing they could enrol heaps of students, the government would pay the fees, and if the students were unsuccessful, the government would bear the risk. Captain Cook College was one of those dodgy education providers. They began to enrol lots of students who often had no hope of completing their programs because of limited numeracy, literacy, or prior educational achievement. At one point, only 7%, roughly 1 in 15, of the enrolled online students were actually engaged with their program. Section 21 of the Australian Consumer Law prohibits unconscionable conduct in trade or commerce. The Commission alleged that the college's conduct was unconscionable. Justices Wigney and O'Brien noted a finding that conduct is unconscionable is a serious matter. It involves a significant departure from proper commercial behaviour. The word unconscionable is to be understood as bearing its ordinary meaning, being conduct that objectively answers the description of being against conscience. The values that inform the standards of conscience include certainty in commercial transactions, honesty, the absence of trickery or sharp practice, fairness when dealing with customers, the faithful performance of bargains and promises freely made, and the protection of those who are vulnerable from those who would victimise, predate, or take advantage. Their honours found that by recruiting inappropriate students, then making it hard for them to cancel their enrolment, the college was indeed behaving unconscionably. They said the college's conduct should be condemned as unconscionable. The college altered its enrolment processes in a manner that weakened its existing safeguards against the enrolment of unwitting or unsuitable students. It was entirely foreseeable that the college's conduct would result in large numbers of students being enrolled in the online campus in circumstances where the student was unsuitable for enrolment because they lacked sufficient language, literacy or numeracy skills, or technology skills, or access. This case confirmed the strength and flexibility of Section 21. Unconscionability may come in many forms, but if there is a sufficient departure from proper commercial behaviour in a way that is contrary to conscience, the court can step in and apply a remedy.